Imagine you're a worker, whether in tech, healthcare, or sports, and the companies hiring you secretly agree not to compete for your talent. No wage bidding wars, no better offers, no freedom to leverage your skills. Sounds unfair, right? That's exactly what happens in a buyer cartel. Most people think of cartels as businesses fixing the prices they sell at. But cartels can form on the buying side too. Supermarkets might collude to pay farmers less. Hospitals could coordinate to squeeze down doctors' fees. In labor markets, employers can fix wages or promise not to hire from each other. The result? Sellers, whether they are workers or farmers or small suppliers, are denied the benefits of fair competition. Prices and wages are artificially suppressed. Opportunities dry up and innovation suffers. That's why competition law, once focused mainly on price fixing between sellers, is increasingly being applied to buyer cartels. In the next few minutes, we'll explore how buyer cartels work, why they are harmful, and how competition law is stepping in to protect fair markets and fair work.
In June 2025, the Commission imposed its first fine in a labor market infringement. In particular, the Commission fined Delivery Hero and Glovo, two major food delivery platforms, a total of €329 million for a 4-year cartel. This is a settlement decision, so the parties acknowledge the nature of a cartel, of the infringement, and the fact it was a restriction of competition by object. The investigation started ex officio, so it means of the Commission's own initiative, after receiving information from a national competition authority and through the Commission's anonymous whistleblower tool. This is the first case in which the Commission imposes a fine for a labor market infringement, and the first case in which the Commission fines a minority non-controlling investment in a competitor was used to facilitate anti-competitive agreements. The case involves 3 interconnected anti-competitive practices. First, the labor market infringement, so a form of no-poach. Second, the exchange of commercially sensitive information. And third, geographic market allocation. Let's start with the no-poach. The no-poach had 2 components. First, the parties signed shareholders' agreements, including reciprocal no-hire clauses, entirely preventing them from hiring certain specific managers or key employees. Second, they reached a wider agreement not to actively recruit all of each other's employees, although this did not extend to the delivery riders. These agreements generally constitute purchasing cartels, meaning that they suppress wages and limit labor market mobility, and they impact on market productivity. Moreover, the economic and legal context shows that Glovo saw the relevant workers as scarce and in high demand, and used active solicitation as a decisive source of talent to drive its expansion. On this basis, both the no-hire and the non-solicit qualified as restrictions by object. The no-hire obligations were not considered ancillary restraints, as they were not objectively necessary for or proportionate to the relevant investment agreements, because they were unlimited in duration and territory, they were de facto reciprocal, and they only applied to certain minority investors, not to all of them. More generally, there may be instances in which a no-poach agreement would be considered acceptable, for instance, in the context of a legitimate temporary joint project or a subcontracting agreement, if the clause is limited to the project duration and territory and only covers the directly involved staff. The parties exchange information far beyond what is allowed between competitors, even in a minority shareholding situation. The exchange covered 6 categories of information, including, for instance, future pricing, future supply capacities, and future commercial strategy. Then moving on to market sharing, the parties removed the existing overlaps between them and avoided creating new overlaps. How did they do that? Through M&A transactions. Delivery Hero sold its operations in Bulgaria, Croatia, and Romania to Glovo, for instance, through the coordination of their entry and re-entry in the markets with either of them was already present, and through coordination of their entry into markets where neither of them was yet present. So overall, this is the first instance in which the Commission applied its policy brief on labor markets, and it provides, the first example of concrete application to the facts of this case. and hopefully it provides practical guidance on how the Commission will approach similar cases in the future.
The interaction between labor market and competition law is actually not a new issue. At the French Competition Authority, we looked at this issues, but in a different way than what we just did in our first decision looking at the no-poach agreement specifically. The focus was this time on no-poach and no-hiring provisions, and it concerned a different sector than what we are usually dealing with. It concerned the engineering and technology consulting sector and the IT service sector, so where you have high specialized skilled consultant in very specific technologies and in very technical sectors. Case on no-poach continued, and we found two types of practices. One was a general gentleman's agreement, that's a general agreement, and the other no-poach provision we had were clauses linked to a contract or to a specific project. The general or gentleman's agreement concerned actually the entire sector, was not limited in duration, was not limited in terms of clients or in terms of project. They were mostly informal, so we had different evidence that these agreements existed between competitors. Unlike the clauses where you had the more defined prohibition to poach employees of your competitor, or prohibition to also hire the employees of your competitor when you received a request or a solicitation from them, or an application from these employees. For the gentleman's agreement, we consider that because they were very vast in terms of clients, projects, person concerned, and the sector and the duration, we considered that this was a practice that was illegal by object. So we sanctioned the companies that actually had this type of gentleman's agreement. The fine amounted to 29.5 million euro. And this is why we decided to impose the publication of this decision on the social network LinkedIn, where these skilled people find employment and actually solicitate employers. And we also ask for this decision to be published in specialized journal. These concerns are still the focus of the French Competition Authority, and we will continue to look at different contracts and different practices in sectors to avoid that this very important asset, this human resources parameter that is a competitive asset, especially in these type of sectors where highly skilled people are needed, that these are not part of anti-competitive practices.
To conclude, the message is clear. Buyer cartels don't just distort markets, they undermine fairness. From farmers underpaid for their harvest, to suppliers squeezed on margins, or yet workers trapped in artificially in low wages. The impact is felt across society. That's why competition authorities worldwide are acting, tackling wage fixing, no-poach deals, and collusion in supply chains. The signal is unmistakable. Collusion on the buying side is every bit as illegal and damaging as collusion on the selling side. For businesses, that means fair play. For workers and suppliers, it means a better chance to compete, earn, and grow. And for all of us, it's a reminder that fair competition is the foundation of fair opportunity.